in case number CV 220585, Smith versus Smith. Just a couple of reminders, counsel. We are recording the argument, or at least we hope we're recording the argument. So please identify yourselves and your client at the beginning of your argument. Counsel for appellant, you'll have, or each side will have 20 minutes, but counsel for appellant, if you'll watch the clock as best you can, I'll try to keep an eye on the clock as well. And if you'll reserve as much time as you want for rebuttal, please keep in mind that neither of you need to feel obligated to take the entire 20 minutes. I mean, just depends on the questions that we may or may not have. And so also, please keep in mind, we've read the briefs, we've studied the record, and we have discussed the case in conference. With that, counsel for appellant, Ms. Hoffman, you may proceed.
Thank you, Your Honor. May it please the court, my name is Amy Wilkins Hoffman, representing appellant Stephen Smith. I'd like to reserve 2 minutes for rebuttal. The issue before the court is whether father is entitled to a credit or payment from mother's exclusive use of the community home post service of petition. This is an issue that has been considered in the context of reimbursement to the community. For example, if one spouse uses separate property after service of the petition for dissolution to pay the mortgage on the community house and makes a claim for reimbursement from the other spouse, the other non-occupying spouse may be entitled to an offset of those payments for fair market rental value if there was ouster.
Excuse me, counsel. I'd like to just jump all the way in at kind of maybe what is the bottom part of this analysis. Let's assume for the sake of discussion that you're right, that your client was ousted. Let's assume for the sake of discussion that there is some legal authority for outside of the rents context to make a request like the one your client made. Why would it not be within the ambit of the Yavapai County Superior Court's sound discretion to decide that this not exactly 50-50 division of everything is still even and fair? Why is it not within basic discretion of the trial court in this situation, assuming everything else you say is right?
Your Honor, I agree. The equitable division of community property is absolutely within the trial court's sound discretion. But here, the trial court's decision was informed by a misstep, and not really a misstep, because I believe this issue is one of first impression in Arizona, so we can't blame the trial court for not doing it. But saying Farrell versus Farrell, in which we established this ouster rule, doesn't really apply here because there's no mortgage. So looking at it in the context of reimbursement, it doesn't squarely fit. If this court decides this case and says, trial courts, you can consider the fair market value even outside the context of reimbursement of mortgages, then it becomes a different situation for the trial court in looking at the equitable division of community property.
But didn't the court say that, even assuming everything else runs downhill for you, I still decide based on my equitable discretion? So aren't you just left at the end of the day that assuming it's not a novel case, assuming you're right about ouster, you have to basically say the court doesn't even have the discretion to do this? Aren't you left with that?
I'm not sure I understand the question exactly. I do think that, as I said before, yes, the court has the discretion to decide the equitable division of community property, but had the court had this court's guidance that rental in the context of ouster was available, that the court might have come to a different decision, especially because the court divided everything else right down the middle.
So it's an abuse of discretion because we hadn't clearly told the court it could consider outside the rental context present in the facts of Farrell. So the court abused its discretion because it didn't realize it had the full license to divide as you would request. That's kind of what you're saying.
Yes, but I believe, for example, in the Dede case, that was brought, actually, I was counsel on that case, and that got remanded because Farrell hadn't been decided yet. So there was a remand for the issue of ouster. It wasn't so much that the court abused its discretion, but based on the new case law coming out, this court said, okay, let's send that one back and we can have that fact finding on ouster. It's not so much that we're saying the trial court abused its discretion by not having the benefit of a decision that hadn't been made yet, if that makes sense. So Farrell was decided by looking at the law of joint tenancy. And joint tenancy and community property are not exactly the same, as this court well knows. However, in certain instances they are. And in one of those instances is that each spouse generally retains the right to use community property even after service of the petition for dissolution. Joint tenancy, same. Both tenants have the equal right to use the property. So with joint tenancy, and this goes back to a 1974 case, I found a good definition in Oppenheimer versus Oppenheimer 49 years ago, where the occupying tenant has ousted his co-owners and excluded them from possession of the property or a part thereof, he must answer for the value of the use and occupation. That's squarely in line with what happens in a community property case or a dissolution case, where one spouse is going to occupy that property and there's an ouster. There should be a right to reimbursement.
So a right that's not discretionary, then it sounds like what you're saying, that rule that you're proposing should control, even to the extent of displacing the court's otherwise acknowledged discretion to divide assets equitably. That's what I hear you saying, counsel.
Your Honor, respectfully, I wouldn't go that far. I think that what we need to do is make that an option to the trial courts, because this hasn't been squarely decided before. I think this probably comes up in quite a few petition for dissolution cases where one spouse is still in the house and the other is not. And trial courts could have that as an arrow in their quiver of how they equitably distribute community property.
Have what in their quiver?
The right to, or the knowledge that they could distribute the fair market value of the rent to one spouse as part of this distribution of all assets.
But I think the court thought it had that arrow in its quiver, because I thought the court said it exercised its discretion to do equitable division, even assuming the correctness of your position. So I'm not sure that really brings anything extra to the analytic process this judge exercised.
You know, Judge Hancock did a thorough analysis. Judge Hancock looked at McElwain, and that is the case that we are urging this court to take a close look at. McElwain is out of the Virginia Court of Appeals. Not exactly our neighbor, but a sister court nonetheless. But started with the proposition that first Farrell doesn't apply, then looked at McElwain, and then looked at various other factors and did make a decision that it didn't apply. My argument is it would have been a stretch for this court to actually apply the rents when there is no authority on point from the Arizona Court of Appeals or Supreme Court that it could do this. It rejected this argument mainly because Farrell was a mortgage case and this case is not.
So, counsel, I have two questions. One,
Yes,
you're
Judge.
seeking pre-service, pre-filing rent, right?
Yes.
Any
isn't-
case in Arizona that says you can go back pre-decree on this?
No, there
Okay.
isn't. And
So
that would be.
Go ahead.
Oh, and that would be something that this court could establish, because this is a case where the ouster happened pre-petition for dissolution, but the character of the asset didn't change, of course. It's still community property before and after.
Do you have any case that says, and this is, I think, the challenge for you in this case, that when the person has left the home, because there is an order of protection and because the victim of some sort of disorderly conduct remains in the home, that's an ouster? Because I'm struggling with how it's an ouster under these facts, because a court order is the reason he couldn't go back. Doesn't matter who sought it. There was a finding and he pled no contest, which, as someone who has taken these pleas, they're told this is the same as pleading guilty and all the consequences of pleading guilty. So how do I ever even get to an ouster?
I disagree, Judge. I feel like an order of protection precluding my client from going within 500 feet of the marital home is an effective ouster. That spouse cannot share the home, wife doesn't need to take the extra step and saying, by the way, I changed the locks. And I would look at the Morga versus Friedlander case. And the reason I would look at that case is because it has to do with intentional conduct. In that case, two lawyers were sharing an office. One lawyer moved out. The other lawyer had to pay the rent and so locked him out. And they still found there was an ouster, even though, the first lawyer basically caused the situation by saying, I'm out of here and I'm not coming back. So the reason I bring that up is I believe that wife argued husband basically did this to himself with his conduct that resulted in the order, but that's not necessarily what ouster is. If one tenant is precluded from possession of the jointly owned asset, there's been ouster.
But it wasn't by the spouse changing the locks. This was because the court ordered it under Arizona law and had a right to do it, and then later pled no contest to the criminal act that also supported that. So I'm struggling. It doesn't seem to me to be on the same par with one co-tenant changing the locks. So do you have any case where this sort of situation has resulted in a finding of an ouster? Because I'm not familiar with one.
No, Your Honor, I'd be happy to look into that for you, but no, I don't have that particular
Okay.
case with ouster. I would suggest to the court, if that they are inclined to find in my client's favor, that remand on ouster might be appropriate, as the court did in the Didi case, simply because when the court decided that Farrell didn't apply, the court had no reason to make that finding as to whether or not there was ouster. So there might be perhaps other evidence that if it's limited to ouster that the parties might want to introduce. But no, I don't have anything specifically on an order of protection constituting ouster.
Okay.
Counsel, if I can jump in for a second, just
Yes.
following up on Judge Jacobs' questions or observations about the sort of the broad power, authority, if you will, given to our trial judges in the context of domestic relations. And it seems like, and you referenced the Friedlander case, but I guess I find it kind of odd that to think that we would bring in commercial lease principles, commercial lockout principles into the domestic relations context, where it's such a how do I say this? It's more of a touchy-feely type of area of the law, where it's just it can't be black and white. Unfortunately, I mean there's a lot of equitable. It's the whole doctrine is on even statutes are based upon what's equitable, and we're not going to draw. Our courts have said over and over, we're not going to draw this mathematical formula under, and many cases speak to that, as you know. So I still struggle with that and wonder, so do you really think that we could bring in that principle of the commercial lockout? I just don't see how that translates to this case.
Your Honor, I don't think it's too far a stretch, given that Farrell relied on principles of joint tenancy. And Morga is a commercial lockout case, but joint tenancy principles, of course, apply residentially. And yes, it's an equitable decision. We have to give the trial courts tons of discretion because cases are so different on their facts, and what is fair is different on the facts. But in this case, what would have been fair is if my client received some compensation for having to move to Wisconsin, live with his parents. Wife's life wasn't uprooted at all, just continued to live in the house. And when I was thinking about this, one of the things I thought about was fairness, because it could be that a spouse might feel really surprised at trial to learn that there's rent owed. And this could be something that could be brought up in temporary orders hearings, saying, okay, we know that one spouse is going to live in the house, one spouse is going to live somewhere else. And that could be discussed so that it isn't trial by surprise, but still leaves the trial court this discretion to go, gosh, in this situation where everything else is fair, I know that I have this power to divide or assign rent.
I guess I had a very different reaction to a fact that you cited, counsel, because I think you said at the start how the court was doing everything else 50-50, kind of, why not this? Well, I heard you say something like that. And I guess from an equity standpoint, going to the point that you just made, I understand your client thinking he's ousted, and I don't think your property rights vanish when you commit an act of domestic violence, for example. So I could go with you that far, but your client also, just from a fairness standpoint, putting aside that incident, was not contributing. Maybe he wasn't able to, but he wasn't trying to contribute to the welfare of the child while he was away from the home as well. So why wouldn't that be a basis for the court exercising, like Judge Brown said, its equitable authority to otherwise be even about this? That's where I'm stuck.
Okay, Judge, I'm glad you brought that up. There are cases in which payments to community obligations have been treated as family support. And one of those cases is the Barron case. And in that case, this court found that wife could not have met her obligations without husband having paid the bills, such as the mortgage, the community obligations. So declined her husband's request for reimbursement and decided to treat it as spousal support. This is a very different situation. In this case, at the decree stage, the trial court says wife isn't entitled to spousal maintenance. Also, wife waited a year before filing her petition for dissolution, filed for temporary orders, but did not seek retroactive child support, which she could have done. That is available. You can get retroactive child support if the parties haven't been living together prior to service of the petition. So in that sense, yes, you could take a community contribution and treat it as support, and husband had not paid child support, but almost immediately was assigned child support after wife filed the petition for dissolution 2 months later at the temporary orders hearing and paid it. So I think it's not squarely to say that husband didn't contribute at all, because once the dissolution action started, he did.
Thank you.
I have hit my points, so I'm going to reserve the rest of my time for rebuttal unless anyone has any other questions for me.
Okay, no,
Thank
okay,
you.
thank you, counsel. Mr. Hull.
Yes, good morning, Your Honors. My name is John Mull. I am counsel for appellee wife, and my approach in this case is pretty straightforward. I look at Judge Hancock's ruling as being entirely appropriate under the large umbrella of equitable powers that the court has to divide property under 25-318. I referenced I spent some time talking about the Virginia case, because if you add a list of things that the court must consider, well, then I think you're going down a slippery slope. Our statute doesn't have any particular elements or lists of things that your honors have to consider. It gives all of that discretion to the trial courts. And in this case, it was a substantially equal division of property, because Judge Hancock, one, found that husband did not meet his burden in proving fair market rent. So he doesn't get over that hurdle initially. He presented some evidence, but not enough to convince Judge Hancock that was sufficient. Notwithstanding that lack of evidence, Judge Hancock then considered in the alternative or conditionally that even if I accepted your numbers, husband, it's not resulting in a fair and equitable division. And what the judge did is I think she did consider the fact that wife spent her separate funds, not community funds. She spent separate funds to keep up the home, and in addition, pay for the child. And all of those things, I think, were fairly considered and offset against husband's claims for rent. Mother had to do this before the petition was filed, and the numbers honestly were almost about the same. I mean, if I was the judge, I might say it's almost a wash here. That's maybe how she did it. I don't know, but I don't believe that this was in any way unfair or inequitable based on the evidence that was presented and husband's failure to get over that hurdle. I don't think this is an ouster case. I couldn't find any case law that didn't deal with where you have a mortgage, which is the only case law that I think the Dede case and the Farrell case talked about. The judge didn't cite the Farrell case, in my opinion, for talking about ouster. It cited it based on its requirement that the party claiming that defense or claim has to prove fair market rent sufficiently. And again, I think the court looked at this Virginia case, and what it did is it found, it used that to say, one, you got to have an expert to help support your claim for fair market rent. Two, you have to look at what the contributions were and what the party's financial positions were at the end of the day in determining what a fair and equitable division of property is.
But Mr. Mull,
yes.
would you agree that at bottom, whether or not there's an ouster or whether or not you're right about rents, that the court made an alternative holding at the end that backstopped all of this with reference to the general broad equitable authority that Judge Brown and I were discussing? Would you agree that at bottom, that's kind of where you end up?
Yeah, Judge, after everything settles to the bottom of the glass, that's where I think you're left. And so I don't think your honors have to plug in a mandatory requirement that every court consider rent, because I think that's part of the broad discretionary powers that the court has anyway. And then, like I said, you're going to be adding additional items in each case that the courts have to consider. I don't think that's the intent of the statute.
And I don't think we have to write something really tricky about ouster to decide this case necessarily either, do we?
I don't think so, Judge. I just don't think it's an ouster case, because we have a case where the person that's seeking ouster is claiming that his own conduct constituted the ouster.
Well,
I don't think that
Mr. Mull, I'm trying to make it easier for you. I think we don't have to determine that issue for you to prevail necessarily. That's what I was suggesting. Am I wrong?
No, you're not wrong. And that's why I didn't think it's an ouster case. I wasn't trying to argue against my argument. Finally, Judge,
before you move on, though, counsel, if I could just very quickly,
Sure.
because it seems to me that all of these commercial cases, the other co-tenancies, the issue isn't an equitable division. That's what those cases are about is different. We hear the charge was fair and equitable, and this is where, I think all three of us are looking at, which is when you look at all of it, when you look at why he wasn't in the home, when you look at what was going on, when you look at there is no mortgage, it was fully within the judge's discretion to look at all of that and go, the fair and equitable resolution is no rent compensation. Is that a fair assessment that the other co-tenancy cases really don't apply? They're not using the same legal standard we're using here.
I agree, Judge. And my final comment is, in the reply brief, counsel did not reference this Pownall case, is what she talked about in her initial opening brief. But I mean, I don't believe that lends any additional authority. That was the same argument that was made in the DD case, and the court did not accept that argument. So, Judge, that's really all I have to say. There's really not anything more. It's a pretty straightforward case, at least from our perspective, and we'd ask that you affirm. Thank you.
Okay, thank you. In rebuttal, Ms. Hoffman, got it. Go ahead.
And counsel, I would just say, returning to the very first thing that I asked you, on one hand, let's assume you're right about ouster. Let's assume you're right about Farrell. Why is this an abuse of discretion under the principles of equity we've been discussing? That's where I'm stuck at.
It's an abuse of discretion in that the property was not divided substantially equally because wife received a $30,000 windfall. And that happened because this court has not yet provided guidance to the trial courts that this is possible outside the realm of mortgage reimbursement. I just had one short point on rebuttal, and I wanted to talk about the evidence of fair market rent. Admittedly, the testimony was pretty succinct on this issue, but my client did testify as to the fair market value of the rent as $2,600 a month. And the trial court acknowledged that he testified to that, but was what I would call dismissive of it, saying, other than his testimony has been provided no evidence. And just wanted to make the point, and I know the court is well aware, owner opinion is evidence of value. And the trial court also had evidence of the value of the appraisals to find that a $669,000 home, a 3-bedroom home, has zero market value is an abuse of discretion. So I just wanted to emphasize that point. Unless the court has anything else for me, I think I'm done. Thank you.
Okay, unless anybody has further questions, my colleagues, I'm hearing none. Okay, the court will, thank you both for your arguments this morning. We'll take this matter under advisement and we'll issue a decision in due course. Thank you very much.
Thank you.
Thank you.